Good evening, everyone. Please confirm if I'm audible.
Yes, sir.
Okay, great.
Yes, sir.
Yeah. So we'll start with today's session. In the last two sessions, we had discussed fundamentals of constitutional law, and especially we had focused on fundamental rights. So if you have any questions with regard to right to equality, right to non-discrimination, freedom of speech, the tests that are there to determine if there is unequal treatment or right to discrimination, or what is the scope of freedom of speech and expression, then I can begin by taking questions from fundamental rights.
No, sir, no questions.
Great. So today we are starting with criminal law, and what I would want all of you to be familiar with after the end of uh, two sessions, this session and the next session, is that how is it that law looks at criminal law, and we'll focus on three components of criminal law. First is that how do you define offenses? How is it that a court looks at offenses? What are the requirements for finding someone guilty of having committed a criminal wrong? Then the second aspect of it would be that how investigation happens under criminal law. And the third aspect of it is that when the matter goes to the court, which is that when court looks at a charge sheet or charge, then what are the kind of evidence that the court can accept to determine the guilt of the person. So the first thing is that let me just take you to without the law part. Let me just tell you what are the different stages in determining offense under criminal law. And these are things that you must be knowing, but I'll give them legal names so that you are able to mentally picture how where the three laws that are there, which are known as criminal laws, which one is BNS, Bharatiya Nagrikta Sanrakshan, then BNSS, which is Criminal Procedure Code, and BNS, which is and BSA, which is evidence law. At what stages do all of these come together? So before that, I just want to know that you don't have to tell me the law, but suppose if a wrong has been committed, some offense has been committed, and that comes to the light, then what do you think if you have witnessed it, then what is the first step that you will take? Yes, Vadevi.
File an FIR.
Okay. So the first is the criminal machinery is triggered with filing a complaint, right?
Yes, sir.
And then just keep going on. What do you think are the next stages?
You
You
would,
file a complaint. Then the police looks into the complaint,
and
decides
then,
if what you are saying is correct or not, might conduct a preliminary inquiry, and then if they think that there is ground in what the complaint is, then they will turn that preliminary complaint into an FIR. Okay.
investigation.
From here, what happens? What do you think are the next stages?
Sir, I don't know.
I'm asking the class to think about it. Because if we have all lived in India and if we have all consumed copious crime dramas and we have some idea about what would happen, what do you think will happen next?
So, if I were to guess, there would be an investigation which takes place,
Okay,
and
yes,
then
you're
there would be a
correct.
court
Stop
hearing.
there. Stop there. Let me just tell you. So you are saying that suppose the police registers an FIR or a complaint,
Okay.
And on that basis, you are correct that an investigation will happen. Now, if there is an investigation, if there is a person of interest, which means that if the complaint is against someone and the police thinks that there is reason to believe that this person has committed a wrong, then investigation will start. What do you think are the stages of investigation? How will investigative agency or police try to gather evidence or look into how the crime has been committed?
I don't know,
What do
sir.
you think? If you have watched movies also or have read about it, how does police conduct investigation?
So first they analyze the crime scene.
Okay. First they analyze the crime scene, correct? Then,
Then they would talk to any witnesses that may have been there, and then try to like pull on the leads.
hmm. So they will speak to witnesses, they will try and gather if there are eyewitnesses to that, and they will all be noting it in the case diary where FIR has been filed. Okay. Anisha, yes. Keep adding to
I'm
it. I just
okay,
want
so
to
I'm
say,
basing this completely on TV shows. But in Dexter, like this show called Dexter, they also take collection of evidence. Like they
hmm,
take photos of the crime scene and
hmm,
any like
hmm.
clues left behind or hints or anything.
Okay, okay. So all of you are correct, which is that they will go about, first thing that they will do is they will conduct a preliminary inquiry on their own. And if there is a complaint, then they would try to see that if they can gather evidence, which will then take the form of a combination of all of these things. That they will go to the crime scene, they'll try securing the crime scene if it is still something that can be preserved, which can give them clue about how things have happened. They might ask witnesses and they might call people to come and give information about that crime. They will engineer their informant network. And then suppose if all of this happens and they have three or four people that they think might be involved in some capacity, then what will they do?
The court takes the statement of the accused.
Okay. Statement of the accused. So if they take the statement of the accused, then they will ask the accused to come to the police station th- so that they would want to know from them if they are involved or not. And I am saying that if the police suspects that there is a chance that that one of the person is the accused or might be involved in it, then
They bring them in for questioning.
but for questioning, let me tell you, if I am the accused, I will tell them that no, I will not come in for questioning. Then I will not cooperate.
Can they bring them in to the station?
Good. So what we are trying to do is I am trying to deductively make a sense as to why law is needed. Now, suppose they do their investigation, and in that, some of the people are not cooperating. And from their information, from whatever evidence that they have gathered, they think that this is a person who might have committed it, or there might be more people involved with this person who might have committed this crime, and the people are not cooperating. So the thing that they will do is they will move to the court. Have you heard of these phrases? Arrest warrant,
Yes.
Yes, sir.
search and seizure.
Yes, yes.
Yeah.
So search and seizure is something for which they will move to the court, magistrates, sessions court, and they will say that this is the information that we have, and on basis of this, we want to search the premises of this person, and for that, we want a search and seizure warrant. Now, this is where the judicial mind comes into the picture. There will be a prima facie or on the face of it, whatever evidence is there that the court will present. and the magistrate, if they thinks that what the plausible uh, s- the plausible story that the police has about a certain person being involved, if they think that there is some plausibility means that there's some connection, then they will say that we are issuing a search and seizure warrant. Search and seizure happens of premises and of property, which means that if the court, you must have heard this, that if a police lands up on a door, then if the person who is being investigated has some idea of law, they will ask them that where is your search and seizure warrant, or where is the warrant? Otherwise, you can't enter my premises, you can't enter my office space.
Yes, sir.
So this comes under, what do you think, which law, under which law will this come? This will come under Criminal Procedure Code. That
CRPC.
what are the safeguards that the police need to respect when it is investigating? And it means that it needs search and seizure warrant, and it needs to follow some procedure so that the accused is not framed. For instance, search and seizure warrant would also require that the police lands up at the premise of the individual with independent witnesses. Independent witnesses are people who are independent, who are people whose credentials are unblemished, and so that everything that the police is doing is happening in their presence. The things that are seized, or the things which are searched, and if something is taken into custody, then there is a noting that follows, so that there is some accountability to how the police is conducting the investigation, that the police is not framing an individual. So the investigation then proceeds with search and seizure warrant. If something is recovered from there, which they think in future when they are filing a charge sheet before the court, that might be taken as evidence, then all of that is recorded. And that is why you need a court, so that it happens within the it happens under the eye of the court and under independent witnesses. Similarly, suppose something is recovered from search and seizure warrant, and there are raids in 4 or 5 premises on the basis of search and seizure warrant. Then suppose police thinks that there are two individuals who have a high probability of being connected to the crime, or they might be the accused, and they want to question them rigorously. Then what do you think? Police can suddenly go and pick up those people and keep them in police custody.
No,
So,
I
No, sir,
don't think
because
so.
they would still need an arrest warrant for
okay, yes, you are right.
taking the person into custody.
So if the police wants to again investigate, then it will again move to the court and then seek an arrest warrant. An arrest warrant is a warrant where a person who is an accused can be taken into police custody. And when a person is taken into police custody or is arrested, then also it is the court that gives them the time, which is called that the court might say that you have a right to keep this person who is an accused under custody for 5 days, or for 6 days. That is what you must have heard in a lot of Bollywood movies, where they say that we are seeking remand. Seeking remand means that we are uh, that we want to arrest this person and keep this person in police custody for 5 or 6 days, where we will investigate, will confront that person with that evidence in order to then construct the sequence of crime. This is how arrest warrant has to be issued. What is the procedure? Can a person be arrested without an arrest warrant. All of this is again, it comes under Criminal Procedure Code. So normally the process is that if during an investigation they think that they are able to zero in on a suspect, then they will seek search and seizure warrant. They will seek arrest warrant, and if that is issued, then for the period of the arrest, which is the arrest warrant gives them custody of the accused for 5 or 6 days. Then during that time, the police can investigate. It can also happen that sometimes a crime has happened suddenly, and there are strong chances, and the eyewitnesses will say that this person is involved, and they want to take control of the situation. So it also gives police the right to arrest a person without arrest warrant and keep that person in custody only for 24 hours. Within that 24 hours, the police has to move to the court seeking arrest warrant or informing the magistrate that because we didn't have time to approach, so we have kept this person in custody, but that can't be for more than 24 hours. If you look at all of this sequence, what you will see is that the way you look at the law, criminal law is not for punishing the criminals, it is for that. But inherent in it, because it is a law, it determines that there are safeguards that have to be respected by the police, and that is why you say accused have rights. If you think that this is unfair, then you have to again understand you are talking about an accused. You are not talking about a person who, it is not about subjectively determining whether the person is guilty or not. And therefore, these are in the nature of CRPC gives powers as well as safeguards. Power to the police as well as safeguards to the accused. And safeguards to the accused are part of fundamental rights, right to life. And the purpose of this is safeguards are necessary because safeguards are given to the weaker party. Here, if there is all the criminal cases that are there, if you look at the names, it would be name of the accused versus Union of India. So this means that
Yes,
here the stronger party is the Union of India because it has the paraphernalia of investigation, the police machinery. And facing that paraphernalia is a single individual who is a suspect. So there are boundaries that must be respected. It is not that boundaries of civility, boundaries of how investigation has to be done, these are not respected if the crime is heinous. And this is what rule of law commitment also means, that everything will happen within the bounds. So even if the police is able to arrest a person because they didn't have time to get an arrest warrant, they can only keep the person in custody for 24 hours. Then there can be, if they want to search the premises, then they need to get search and seizure warrant. Then what do you think is the next stage? Suppose the accused is kept in custody for 6 days. Then what will happen after 6 days? If the police wants to continue the investigation and keep the person in custody, then how can the police do it? Then after 6 days, when there will be another hearing in a court, and there is the investigative agency or the police who is being represented by a public prosecutor will argue that we demand extension of remand. Then there will be examination by the court, and court will look into those things. That have you registered an FIR against this person? What is it that you have where you think that you need more time? Why do you need more time? How many of you think that the court asking these questions about why the police needs more time to investigate and keep the person in custody is something that is too lenient? Is there anyone like that?
Sure, I'm sorry, could you repeat your question, the last part?
The part is that if when investigation is going on, then also there is judicial oversight. And if police wants to keep a person in custody beyond the time that is guaranteed by the court and seeks an extension of custody, then how many of you think that this kind of questioning by the court when police is investigating is the court being too lenient in favor of the accused? So the principle that is governing this kind of judicial oversight and also determining that investigation has to happen within with rights of the accused also being protected. This has to do with the cardinal principle of criminal law, which is that everyone is presumed to be innocent until proven guilty. So the presumption is that the person might be innocent. He has not been proven guilty. So the
Burden
procedure
of
cannot
proof.
turn into a grueling punishment. That is why even for extension of police custody or remand, they have to move to the court and satisfy the court that it is in the interest of the investigation that the accused is kept in remand. Because if the accused is released, they will argue that what happens is that this is a person, if the person flees, then the whole investigation will be hampered. Or the person who is there, who is in custody, if they are released, then they might go and intimidate some witnesses. Or the scene of crime which is there is this place where the accused can go and fiddle with the crime scene. So it is in the interest of justice to keep the person in custody, conduct an investigation, so that the possibility that the person is either a flight risk, or the accused becomes a flight risk, or the accused intimidates a witness, or the accused is impairing the investigation, all of these things can be frustrated. Now, suppose the court gives them police custody uh, for 15 days or 16 days. Then also, when a person is being investigated, the person can in that time move to the court for bail. Bail means that they would try to satisfy the court that we have cooperated with the police and we are willing to abide by the conditions, but we should be released because we are under trials, that or we are accused in this case, and the police cannot keep us in custody for very long because we are presumed to be innocent until proven guilty. So suppose after all of this, what do you think, if police is able to have a plausible picture about who has committed the crime, what kind of offense has been done, then what do you think is the next stage?
So then both the accused and the defendant will be brought to court, and the statement of the accused is taken, and the prosecutor decides to.
Okay, hold on. Well, I think we are jumping a few steps. So how is it? So tell me this: if police files a report which is known as a charge sheet. Charge sheet means that police is able to build a case, and it names some people as accused 1, 2, and 3. It also lists down the offenses that they have committed. And but for it to go to court, can everything that police says will mean, if police says that this person has committed the crime, will that matter be committed to the court? It will not be committed to the court. Then what happens is, after police does its investigation, it files a charge sheet. Then the magistrate or the session court judge depending on what kind of offense is there, they will then study the charge sheet. Charge sheet is nothing else but police version of what has happened. And if they think that what police has said is making sense, then the legal term that is there is that it is the court that frames the charge. Framing of charge means that the matter has now been committed to the court, the magistrate has accepted the charge sheet, and then it is then the court that frames the charge against the accused for commission of specific offenses. Then the matter comes to the court. Sometimes it can also happen that the investigation has been so shoddy that they have filed a charge sheet which does not stand scrutiny, which means that the magistrate looks at it, asks them a few questions, and say that no, we are not satisfied. This is not enough for us to frame charge. All of it is also part of a safeguard. Then again, there is application of judicial mind. Police files the charge sheet, which is where investigation is over. It is their version of the story, which will then be pushed or argued by the prosecution. But for court to take cognizance of it, it requires that the court sees that what they have filed in terms of charge sheet is something on which there is ground for framing of charge against the accused. So here comes in the third law, which is Indian Evidence Act or Bharatiya Sakshya Adhiniyam. Sakshya means evidence. Once court frames the charge, then the legal term comes, which is that there is an accused or there is a defendant and there is a prosecution. Prosecution means the state. Defendant means the persons against whom charges have been framed. And then what do you think happens when the matter is committed to the court? There is a bench, there is a court that is formed, charge sheet is accepted, charges are framed, state has to prove that the wrong has been committed, and defendant will be given the chance to question that version. So always remember, if the cardinal principle is innocent until proven guilty, then it is upon the prosecution to show that wrong has been committed by bringing in witnesses who give testimony, by giving in electronic evidence, by bringing in evidence that were part of search and seizure, to then create a story which will link the accused to the scene of crime and show beyond reasonable doubt that accused is guilty or defendant is guilty. So here also the principle is innocent until proven guilty, which means that it is for the prosecution to prove their case, and it is not for the defendant to show that they have not done it. Also, we are talking about criminal matter, which means that there is a criminal code only with respect to wrongs that the society as a whole thinks is a wrong. So the standard of proof that is required is not mere probability that there is chance that they might have done it. It is a much higher threshold. And the higher threshold is that the prosecution has to prove their case beyond reasonable doubt. Beyond reasonable doubt means that they have to show that with almost certainty, because one can't go back in time and look at what has happened, but it has to provide evidence in a manner that the court is convinced with almost certainty that the defendant is guilty. That is why you will sometimes see that even if something has happened in public view, and let me just tell you, if evidence is not recorded properly, if witnesses' statement are not recorded, if there is fiddling with scene of crime, if there has been search or seizure without there being witnesses, where witnesses have not signed, if the manner in which photographs have been taken, but if they have not been digitalized in a format that the court thinks is authentic, then the whole case will crumble because one has to prove guilt before the court. And that is why the part about evidence is very crucial, because it is not about one producing evidence, but evidence that has to be given as per the law and recorded as per the law. And it is at this stage that lawyers generally come in. They might come in earlier also for getting bail, which is the prosecution and the defendant. So it is at this stage that the trial will commence. And the first thing, what do you think? What have you seen in movies? What happens when a trial is conducted?
Plea bargain.
No, plea bargaining, first of all, is an American concept. It has come into Indian law only in 2005. Plea bargaining means that if the defendant
Has
accepts
information.
that they have committed the crime and cooperates in investigation, then with respect to less serious offenses, not for murder and these things, for which punishment of the crime is less than 5 years, generally they might enter a plea bargaining so that the prosecution can secure conviction, and in return for that the defendant will get a reduced sentence. So that is an aside. I'm asking you to think very sensically. If the court starts hearing a matter, what do you think? What are the things that play out?
Opening statements along with the prosecution presenting their facts and evidences, then the defendants defending whatever the prosecution said, and then closing statements.
Okay, you are right, but let me just tell you what are the terms that are used.
Wait,
So
but
do you
sir,
think
is it?
that who calls witnesses? If
Sir, I
we
have a
say that we are
question.
examining witnesses, then
prosecution.
whether witnesses are examined from the side of the prosecution or witnesses are examined from the side of the defendant.
Both.
Both.
You are correct, both. So what happens is when charge is framed, the matter commences, then both of them give a list of witness list. A witness list is given. So if prosecution has a witness list, then that list will also be served to the defendant so that they prepare their cross examination. These terms you must have heard, that a person is going to be a witness and someone is going to do the cross, and it is opportunity which is given to both sides. So there will be defendant witnesses from defendant witness, and there will be prosecution witnesses, and they will come and testify. They will record their evidence. They have to record their evidence in certain format. You must have also seen that lawyers are raising the objection that this kind of question can't be asked, or this is a leading question. How can this be asked? They raise objection to a line of questioning. So all of these things are also as given in part of evidence, that how questions have to be framed. It has to be legal question. It has to do with matter that is relevant. Otherwise, the judge will not accept that witness. So if they are witnesses, then also there can be physical witnesses, and then there can be other kinds of evidence also. You will also see that the prosecution sometimes presents artifacts and things that they seized, and seized in the format that the court has told them to seize it in, to record it in. So all of that is part of the thing where they're trying to prove beyond reasonable doubt that the accused is guilty. From the witness side, you will see the usage of this term, that defendant has an alibi. Now, alibi means that if prosecution is trying to connect the accused to the scene of crime on that day and saying that this person has committed it, if the defendant shows or produces evidence by showing that on the date where when on the time when crime was committed, the person was somewhere else, then that is known as alibi. Alibi means that I have proved that I was not there. So this is the way evidence is, there is a format in which evidence is registered, which is the term that is used is evidence being admissible, evidence being inadmissible. Now let me come to that. Tell me this. Suppose if I was the lawyer of the accused and the accused confided in me that I have committed this crime, but rule of law requires that that everyone should have a lawyer because they have to be convicted or they have to be found guilty in the court of law. So I choose to be that person's lawyer. And the accused is sharing all information and telling me that whether he is telling that whether there is a plea of unsound mind that can be taken even if I am not unsound, because that will prevent me from because that is an absolute defense. And as a lawyer, do you think that if I pass on this information to the prosecution and tell them that accused has, I have recorded the voice of the accused, and look, the accused here is telling me that he is guilty, use this, can it be used?
No.
No,
No.
Why can't
it's
it be used?
incriminating evidence.
Plus, we can't
Breach
do
of
that.
lawyer-client confidentiality.
Exactly.
There's client confidentiality, you're right. So that is also known as privileged communication, that communication which is privileged either because of the personal relationship or because of the professional relationship. Even if one has evidence, that evidence can't be used against the accused. So this is why I made this distinction between admissible evidence and inadmissible evidence. Inadmissible means that what prosecution is using is privileged communication between a lawyer and a client, or between a client and his doctor. And these are relationships of trust. And that even if it comes to the notice of the court can't use it. Now let me ask you another question. If I was the lawyer of this person and I agree to be his lawyer, then there is a lot of remorse in me because the accused is again recreating or retelling me the stories of how he committed the heinous crime, and out of uh, and with me not being able to take it, I leave his case. I say that no, I can no longer defend you, I will not be your lawyer. And then he hires another lawyer. Then also, do you think that I am bound by the attorney-client privilege?
I think so, yes.
Yes,
Why?
because
Because
someone takes someone as their lawyer, they have to sign an engagement letter stating that this person was my lawyer. And when you leave a case, there's another document in which you state that I'm leaving this case. And any conversation that happened between you signing the engagement letter and the letter which states that you're not taking the case anymore is privileged.
Okay. What you are saying means that there is a contract, but I am asking you a deeper question. That suppose I don't sign that, then also I am asking you as a matter of principle. If there is privileged communication, then it will be privileged communication. Whether I sign that letter or not is if I have been that person's lawyer in that matter, which means that whether I continue to be lawyer or not, I can't pass on information that was shared to me in confidence, because that information was shared to me in confidence. And if I am not engaged in it, that does not mean I can betray the trust of the accused because I am no longer in that relationship with him. Similarly, what are the other instances of privileged communication? Anything that is shared in a criminal matter, anything that is shared between partners, between husband and wife is something where a wife can't be witness. If something has been shared in because of that relationship, where it says that I am only telling you this, that I have committed this wrong. And if it was said in context of that, then it becomes privileged communication. It can't be used. Okay. I'll stop here. There is a question. Yes, Vaday.
Sir, this is in relation to if say the accused has a lawyer and the accused confides in the lawyer saying that they have committed this crime, and then the lawyer decides to leave this client. Is that the right phrase?
Yes.
Anyways, okay, so decides to leave the client. Supposing the lawyer still somehow communicates the fact that the accused is guilty to a judge, it won't be admissible in court, of course, but would there be any legal repercussions to the lawyer
Yes,
for
he
the
will
lawyer?
lose his license to practice. And plus, if the judge seems to be influenced by it with something which is a privileged communication, then and if it comes out, then there will be action on the judge also, because they have betrayed the oath that they have taken under Advocates Act. Even there is Advocates Act which says that you have a relationship of trust with your client. That is what I am saying. It is a different thing, something that has happened. Even if the world knows about what does the rule of law society means, that there will not be people who will judge them guilty without a process, and the process has to be a substantive process that has to take place. So it is not about who has done it or who has not done it. It is what can be proven in court of law.
Okay, got it. Thank you, sir.
Okay. So at this stage, this is another privileged communication. Is there anything that is inadmissible? What is also inadmissible is, remember when investigation was being carried on, then the accused was in custody of the police for some duration. Any admission of crime that happens in company of in police custody is inadmissible. So even if a person or accused writes a letter and signs it and gives it to the police saying that no, I have committed it, and if the investigative agency doesn't know the law and say that we have this we have a signature of this accused, and he has also video recorded this, that he has done it, and what more proof do you need, then that is also inadmissible, because of the principle that is generally assumed that there is power asymmetry or power domination when an accused is in the company of the police. So the chances are that whatever the person has said has said it to in fear of consequences, and might not have said out of own free will, and therefore that thing is inadmissible. If admission is to be made if this kind of admission is to be made is to be allowed in court, then that is known as confession, and confession has to take place before a judicial magistrate with some safeguards, where there it will be asked again and again in the court if the person is saying it under duress or if the person is saying it out of free will. Then only there is a manner in which admission becomes confession, and confession is admissible, but confession happens before a magistrate. So I am telling you that anything that is said before a police is inadmissible. Now here, let me just pause and put this question to you. Suppose there is an accused who is in police custody, and there is rigorous investigation that is happening of that person. And in that investigation, because of the fear of retaliation by the police, the accused says, or the accused admits that that person has committed murder, and on further probing, the accused also says that you can go and recover the murder weapon from this particular place, and you can also recover You can also recover evidence of clothes or some evidence where on clothes where there are blood spots from that location, and I've hidden it there. And if the police goes and gets a search warrant for that place and recovers it, then later on can the accused claim that anything that I have said to the police is inadmissible. So evidence that has been recovered during the course of investigation is also inadmissible.
Sir, I believe the search warrant of the place that has been pointed out by the accused will be asked to the court. Like, so we'll ask for the search warrant. So why would it be inadmissible if the court has warranted the search after examining the evidence given by the accused?
So because the court does not go into, if it is a matter of investigation, then the court does not do a rigorous analysis of it. Which is, if they ask that, they might ask for search warrant for 10 places.
All right.
The point that I'm trying to make here is this. You are correct, but I'm trying to say that try and understand it, that if the person is an accused, and if the accused takes responsibility for the crime but takes it in police custody, then that is inadmissible. But there is another section in evidence as section 27, which says this, that anything recovered or anything discovered during the course of an investigation is admissible in a court of law. So there is a difference between admission before police and admission about evidence that can be used against the accused in a court of law. So recovery of murder weapon or clothes which has blood spot are things where the accused might have given this information to police, and not that the police might have done investigation on their own and has recovered these things. So even if the accused has given information about where one can find those things which links the accused to the scene of crime, then that is seen as discovery during the course of investigation, and that is acceptable. What is inadmissible is the accused's admission of guilt. If accused has to admit to having committed that wrong, then that takes the form of confession. Then on this basis, trial proceeds. And towards the end, the judge, on the basis of beyond reasonable doubt, decides if the person is guilty or not. If the court decides that the person is guilty, accused is guilty, then there is a separate procedure that happens sometimes later on, which is the sentencing. That if a person has committed this offense, then what is the sentence that we have to give? And this is the stage, from whatever we know about a crime being committed to a person being punished, we see how different laws come in at different places, and all of these come with safeguards, and this is what is known as rule of law standards. Okay. So now, do you all have some idea about what are the things that investigation from the stage of investigation to determining the guilt of a person by the court?
Yes, sir.
Yes, sir.
Yes, sir.
So if there are any questions, if there are anything that you want to ask about how laws come in at different stage, how is criminal machinery triggered, what are the powers that are given to the police, what are the safeguards given to the police, how is a trial conducted in a court, what are the kind of questions that the judge might ask? Is there any questions that you have? Then I will first take those questions before moving forward. Yes, Chaitanya.
So I was reading about this case in which it was a sexual harassment and rape case in which the doctor of the individual was called, and the doctor gave the testimony that they seem to be taking pills.
Hmm.
All right, and that testimony was admissible in the court. Then how was it possible? And what is the written proof that this person is my doctor? For example, if I go to someone for like a consultation for like psychiatrist or something, and if I do not like their opinion, I can go to another psychiatrist for a second opinion. So how does it? What proof is there that that person is my doctor?
So first of all, let me just clear it that if you think that there is a slam dunk evidence that a witness will come and say something, and what the witness has said is so piercing or the credibility is so high that the case will turn on that, then that is a wrong way. That is not how law works. A
Alright.
beyond reasonable doubt means that one has to show that the person has done that thing or committed that thing in almost certain terms, and not that there is not some probability. But
Okay.
answering your question, the point I'm trying to make is this, that what is it that the court is trying to do by bringing in witnesses, taking in evidence, that one has to show an unbreakable, almost unbreakable chain of events or circumstances that, when taken together, point point towards the guilt of the accused beyond reasonable doubt.
All right, sir.
So it is a chain of things. But some of the evidence, now coming to your point, some of the evidence can have great weightage. So we are speaking about things where the weightage of the evidence is high.
Yes, sir.
Where will the weightage of the evidence be high?
Sir, that's
Have you heard of this term,
And
dying
in his
testament?
I'm sorry, sir, can you repeat?
Have you heard of this phrase that the person has given a dying declaration?
Yeah, deathbed
Declaration.
confession.
Yes. So that is also not a clinching evidence. That has high evidentiary value, which means that if a person who has lost their life, if they are able to speak to other people in their end time, just before they die, and point towards the people who they think have injured that person or have poisoned them, and that happens in front of independent witnesses who are not interested parties, and if there is recording of that dying declaration, then obviously that will be given high weightage, because it is not just any other person. It
Yes.
is not, it is a person who has suffered and who has lost their life, and towards the end of them losing their life, within the last few moments, they are able to speak and give their statement in front of police or in front of independent witness, which is recorded. So it becomes a high clinching evidence. Similarly, there are some kind of cases that require expert opinion.
Yes.
Now, expert opinion, the doctor that you said, you will realize that the expert opinion is someone where that person, there is a list of impaneled person with the court, a list of impaneled doctors, psychiatrists. And these doesn't have to do with patient and or the defendant's doctors. It is an expert opinion where people who have had that kind of practice and reputation, they are called on to give their opinion or to give their testimony on a thing, because it is a very technical thing. For instance, if certain formulations were given to a person that led to poisoning, and if the doctor is called in as an expert neutral witness to tell if the formulation that is given, if that is generally life threatening formulation, or it is a formulation that, in the case of the patient or in the case of the person who lost their life, it became it had that effect because of internal complications, because of prior complications. So these are neutral third party, neutral witnesses who are called in because of their expertise in a matter. so that on a very technical matter where court does not have expertise, they are able to rely on the testimony of these doctors or psychiatrists or someone else. So the example that you're talking about, they are not, if they are called as prosecution witness or defendant witness, then there would be then there would be then there would not be too thick of a reliance on their evidence. Sometimes it is the court that calls some people as expert witness.
All right, thank you,
Or
sir.
even if a prosecution wants to call someone as an expert witness, if the prosecution asks the court that we would want this doctor to testify, then the court will see that the doctor is testifying as an independent person and is not an interested party in the matter.
All
And
right, sir.
then only it will give reliance.
Thank you, sir.
Thank you. Are there any more questions? Okay. So in next session, we are going to look at the essentials of substantive criminal law, which is we'll look at how offense is defined, what are the ingredients of an offense, what are the general exceptions or defenses that can be taken by the accused, what is the difference between murder, culpable homicide, and death by negligence, what is the difference between abetment and criminal conspiracy, what are taken to be general defenses, which means that even if a person has committed an act which is considered a criminal wrong, are there situations where the accused can or the defendant can be acquitted if they are able to present an evidence, if they are able to present that defense, which is I'm talking about defense of unsoundness of mind, the defense of involuntary intoxication, defense of self-defense, then defense of acting in good faith. Then what are these defenses that are there? So this will then also give you an idea of what is it that one needs to prove to show that the ingredients of an offense are met. Okay. So we'll end the class here. This is a question. How is it determined that the accused who has confessed of committing a crime has genuinely confessed or has confessed saving a relative or some? That is what I said, no? If it is a confession admissible in law, then it can't be given before a police. It can't be given before investigative authority. It has to be given before a magistrate, where the magistrate has to check again and has to check in a format if the accused is confessing to the crime out of without any coercion and out of free will, and if there are reasons to believe that they are doing it under some kind of duress, then the confession will not be taken. So the fact that what is said in police custody is inadmissible because it is not seen as confession answers your question, that it is the magistrate who has to be satisfied that the confession is genuine.
Sir, I had a question.
Yeah, go ahead.
Can someone fleeing a crime scene be considered as evidence?
Fleeing a crime scene. So that is what I'm telling. No, all of this is very circumstantial. Fleeing a crime scene can also be taken against them, but in some cases it will not also be taken against them. For instance, if someone enters a room or if someone enters their friend's house and they see that the friend has been stabbed multiple times and in that state of panic because they think that they would be framed,
Yeah.
they leave. So nothing is a clinching evidence. It will all depend on what are the other things through which that fleeing of that person corroborates the person's guilt. I'm giving you a very normal situation. It can work both ways, no? People can be in such shock that they will look into it, they'll close the door, they'll run away.
Hmm. Yeah.
The other person, but the right thing to do would be what?
Call them.
That to call the police.
Yeah.
But in countries where sometimes a person can also fear that I don't want to be involved in this thing, that or if I don't know the person, then I don't want all of this legal trouble where I become a person of suspect.
Yeah.
So it has to be a combination of things that the prosecution has to show.
Okay, sir.
Thank you. We'll continue the class in next session. Thank you.
Thank you, sir.
Thank you.